Call the meeting to order for a roll call. Oh, actually, I can call the meeting to order and then don't need a second. Roll call, myself, Ty Trauber.
Pat Abney.
Tyler Andrews.
Deanna, I'm an attorney from the Department of Law, provide the board some additional information.
And Amy Solberg, I'm board staff support. You have a quorum.
Excellent. So I move to approve the agenda.
Second.
All in favor?
Aye.
Aye.
And let's see, we have minutes from the previous meeting. I move to accept the minutes from the previous meeting.
Second.
Stands. That clear that. We have no old business, and so we move to new business. So under new business, we have the notice of mediation between the Teamsters 959 and the MLA.
If I could, Ty, this is Dee Ennis, the attorney from the Department of Law. Could I add a little bit of information here?
Okay.
Okay. They have met one time, I believe it was last Tuesday, and they're meeting again tomorrow. So they're actively in mediation. And one of the responsibilities of this board, as Tyler pointed out, was just to approve mediation. And I think that's one of the things that we're looking at the code rewrite that we should take out, that if the parties agree that doesn't require the board approval. But that's what this is about. So the parties are in the knee deep in mediation right now.
So motion is in order to approve a mediation. I so move.
Second.
Okay. So there should be a motion to accept the mediation between the Teamsters 959 and MLA.
Pat did that and I seconded. So
Okay, thank you.
can call the question.
So we call the vote, and I say aye.
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 Thank you. Also under new business, section B, unfair labor practice complaint.
And Ty, again, can I provide some additional information to the board? This is Deanna.
Yes.
I brought to the meeting a copy of the complaint itself, and it's the first 3 pages, or 3 pages outline what it is, and then there's an attachment called ground rules, and I didn't realize they were attached. And this was sent, the union didn't know, this, by the way, for Ty's benefit, is Teamsters Local 959, unfair labor practice against the municipality of Anchorage it happens to be regarding health insurance premiums. And this, nobody quite knew what to do with this because we didn't have an attorney for the board, so I ended up with it. And Ty, who I am, I'm the deputy municipal attorney for Anchorage. I was asked by ER months ago to try to reconstitute this board, and I explained to them what the process, they reached out to all of you. Then we looked to see what more did we need to do, because it's been a fairly inactive board the last couple of years. Before that, it was very, very, very busy. It is heating up. So we need to get you fully working. And one of the first things, if the parties I will represent to you have agreed to defer this, because there is a mediation on, I'm finding this out from another side, there's a, let's see, the Teamsters agreed the change in medical rate for Teamsters employees under the current CBA. The parties agreed to hold the unfair labor practice issue in abeyance until the arbitration has taken place. The parties have selected an arbitrator but not selected the dates for the arbitration. Now, when this first came to the board, what would have been have happened is there's all sorts of deadlines, and you need to have get an independent investigator, I think, and that used to be your attorney. Your attorney did all of that. So it did. Luckily, everybody agreed to the deferral here, but there should be an order from this board agreeing to the deferral, because you have jurisdiction. I had hoped to get that order for you drafted, but it would be very simple, something like, based on the agreement of the parties, this matter, this, what do we call it, LRP. By the way, this is not my subject matter expertise. I am procedural. Whatever you call these things, ULP
Yeah.
will be deferred until the arbitration. The oral, number one, because you have jurisdiction, you need to act, but also that way none of the parties can back out of that agreement. Now they're going to go to arbitration.
So when other labor relations type agencies do this, they often limit the arguments the parties can use later in regard to good faith and some other things. And I'm wondering, I mean, do we have I understand not your subject area, do we have a tradition or some case law or anything, previous precedent where this board has said, okay, we'll let you do your grievance arbitration and mediation process, but the arbitrator can't do this, or did we ever put restrictions on that?
And I don't know that because this board really hasn't been functioning for a couple of years, and that the law firm that represented them has disbanded. So we actually have some of their files, but we have some concern whether those are open to us as one of the parties. So they're sitting now in the Department
Who
of
is
Law.
that?
I'm trying to think of what the name of the firm was. But anyway, they disbanded, and they were inactive toward the tail end of their representation
so it's
anyway.
been a while.
Yeah, it's been a long time. I will say that I looked enough in a horn book to figure out that exactly what you're saying is somewhat true. We certainly don't have that information.
So the NLRB calls it collierizing.
Collier, and in fact, that's what the union representative said. You have to call a meeting of this group, and they need to sign a Collier order of deferral.
But the
Okay.
Collier comes,
Okay, fine.
the board reserves some things to itself and doesn't say, okay, you guys can do any old thing you want to. But I can't remember exactly what that is.
Well, and again, that's why probably the arbitration hasn't even been set, so I'd imagine it's a couple of weeks off. And again, why having your own attorney is really a wise thing to do. I could certainly provide you some of that research, but you'd be better off with an attorney.
Okay.
And by the way, the municipality does this in many instances where, for instance, I'm the attorney for the Board of Equalization, and another attorney in our office is the attorney for the assessor's staff, and we're firewalled, and that's not too uncommon in municipalities.
Sure.
Given my subject matter expertise, I think you should have your own attorney. But we can do that. I mean, I can step in and give you some information if we needed it. I have a feeling that there's not that time crunch here
Okay.
for that. And so we need to talk, eventually move on. But I do need to prepare for you some type of, or if any of you have that expertise, it's simply on a white piece of paper that says, that you agree to defer that, and then call it by that name if you'd like, because that's certainly what the union representative called it. Or I guess you could also reserve that decision till, I don't know, you probably need the parties to be here to make that decision, to make that reservation, to provide you more information.
Yeah, I have a friend we can phone that knows how to do this. I don't remember what would be of interest to the board that we need to reserve that's in our authority.
Yeah, I would actually agree with Tyler in the aspect, this would be very similar where we would allow them to proceed forward with the grievance/arbitration, but at least protect the board's interest and being able to review at a further date.
Well, maybe I make a suggestion that after we talk about attorneys a little bit tonight, that we can, I'm hoping to get an attorney on board within a week, and so then that attorney could advise you.
Yeah, okay. That sounds like a plan.
Yeah, it became clear as I read through your code, there's all sorts of deadlines once this is filed, and we better have somebody for you to be able to meet those deadlines. So maybe the issue here is simply to accept this, but table an order
Thomas Harrison.
until further legal advice.
Oh, wow, that ding dong's pretty strong.
Just forgot to turn it off.
I only do that at the Supreme Court.
Pardon?
I only leave my phone on when I'm at the Supreme Court.
So is this something that and I apologize because I am getting only a percentage of the overall conversation. Is this something that, and I would ask that Tyler put forth the proposition with the proper language, since I don't know if I've caught all the verbiage correctly, we would defer this to the Grievance and Arbitration Committee and make a motion in that manner.
No, this is separate than the arbitration.
Okay.
Two different. I think what Tyler is speaking of is under this doctrine, Collier doctrine, there are certain things the board can say, yes, parties, go ahead and do your arbitration, but we reserve certain decision-making, certain jurisdiction.
Okay.
Yeah. But I don't have enough to put it together right here on the fly.
So, I'm sorry.
So we'd have to care for that. You know, the other thing we could do is, clearly we want the parties to work things out. I'm always a big supporter of that. You know, we could just give them the deferral and say, look, we're not setting any future precedent or limiting our authority in any way. We're just allowing you to do your thing. If other issues pop up that we think are our purview, we will.
And
We
it's
will.
a single issue to
Yeah.
arbitration, so it's just health benefits or something that it's
Right.
limited.
You move something like that, I'll second it.
I'll have to say it again. Ding dang it.
How about, can we say that I will draft an order, and it will simply try to
Sure.
to say what you're talking about.
Okay.
So it will be fairly limited and simple.
Right.
And then at some point later on, you'll have additional input of your own counsel. But I know the parties would like a deferral order out of the board.
So I would move that the assistant, you're the assistant? Deputy, I'm sorry, thank you. The deputy counsel for the city draft an order deferring this ULP to arbitration, reserving any appropriate authorities and rights to the board. That's about it, right?
That would be fine.
Second?
All right, there you go. So we got a motion and a second, Ty.
Excellent. So I'll call the vote. All in favor?
Aye.
Aye.
And
Excellent.
as a point of procedure, once I draft that, I will give it to the clerk's office and you'll disseminate it to these three, or how would you prefer? I'll just give it to the clerk's office, so,
Okay.
okay.
And then would you guys like that in an email or?
That'd be
pick up?
fine with me.
Email's fine.
Email's
All right,
fine?
that makes
Okay.
sense. Great.
Email or text, either one.
Yes, email will be acceptable to me too, please.
Okay.
So last order of business, your new business is the selection and retention of counsel for the board.
And I've heard, various attorneys. Two of the ones that I would suggest to the board, and it's actually, the Department of Law actually makes the final decision, but I want to run them through you, is there's two people that are already selected by both the unions and the municipality to be neutrals in the pre- and post-disciplinary hearings. So they're already neutrals. And, a lot of attorneys don't want to get into this because then they feel they can't represent the municipality in a bigger case or represent someone suing us. So it's hard to find sometimes people that are willing to perform this role. And so the two people that are in that role are Tom Daniels And then, now, I did not have time to get their resumes, but again, we vetted that, we went through this whole process at one point. And then also a retired one, Perry Grover, and he might have had something to do with this board as well, I'm not sure.
They
Yeah.
are both very fine labor attorneys. I've used them both over the years. We couldn't do better. I would say Perry probably a little stronger in some cases.
In
I always
labor.
felt like Tom was a good labor attorney, but a little bit more on the employment side, but a very reasonable person and thoughtful, and I've enjoyed working with both those guys. Perry's terrific. So if we got, if you got either one of those two folks, you couldn't miss. Other folks I wrote down, if you got those two folks lined up, but Mark Torgerson is getting ready to retire from the State Labor Board, and he's clearly well-versed on this stuff. Tom Daniel was on my list. I know he's been a management guy in the past, but Bill Mead is recently retired or semi-retired. He's only taking cases for select clients, and I don't think he does anything with you all.
Who's that?
Bill Mead.
It actually rings a bell, but I can't, but I'll make sure.
He's represented, his practice is primarily employers, so he represented the railroad and Chugach Electric and BP and a
That
few
may
others.
actually have heard of.
Yeah, but I don't think that he does a lot of work with the municipal groups, and I don't think he's ever represented the municipality. But he would be a good choice. I don't think you can get Jandy Young. She's a former head of the State Labor Board. She had Mark's job before he had it. She's terrific. But like I said, Tom and Perry are just top drawer for this town. Just great guys. There's one other name that just floated through my head. That's probably enough. I mean, if you can get Perry or Tom to do it.
Yeah, and that would be my first, because they're
Yeah.
already identified as neutrals,
Right.
so both parties have accepted them in the past.
Yeah.
So do we need to make a motion to accept
Do we,
one of those?
yeah, what
or-
do we?
I don't think you do. I mean,
Okay.
I will go forth,
All right.
give them both a call, and we'll set up whoever says yes, we'll set a little contract. If they don't say yes, then we'll go down the list.
Okay, yeah,
And,
if I can think of anybody else.
So should we defer until both parties have contacted us, or both parties have either accepted or denied?
On which one? On the labor practice one?
The one for the council board.
Oh, no, that's between the Department of Law and you three, the board here.
Okay.
Yeah,
Okay.
no, they don't get input, but luckily, the two main people have already been vetted by both the union and the administration as neutrals.
Okay.
Do they have to be attorneys?
Boy, it sure sounds like attorney-like duties in here, like being able
Well, I
to
mean,
hold a hearing and
Just if
taking in evidence. Yeah.
I don't know what the ordinance and the code stipulate. I mean, a lot of labor relations folks aren't attorneys, and if you look beyond that, it could open up your pool for certain activities. But I don't,
I just quickly went through your code, and I don't think it said they had to be attorneys, but they have to be able to hold, if someone experienced in holding hearings.
yeah.
Well, how about, let me try with the first few here, and if you
Okay.
can get them, I'm hoping Tom or
And I don't. I bet you can't bust him out of retirement because he
Okay.
was pretty sure. But Bob Landau just retired
Oh, yeah?
in
Okay.
April, but
Yeah,
he
he did
was,
a lot of arbitrations for us.
He has to. But he was pretty firm on not taking any more work. But I don't know.
He's too young to retire, I object.
I
I object to that.
I kind of thought the same thing. I was like, you don't look much older than me, but he's a little older than he looks. So
Okay, so I will go forth.
Great.
Try to and then we set them up on little short-term contracts.
Sure.
I think one thing that we'll have to work out with the board is simply that I'm not sure whether they need to be at every meeting or just the cost involved of that is that may want that person for a specific, like this, what is it again, ULP, or the
Yeah.
ULP that came in, because then you have to have an independent investigator.
Sure.
But unlike, say, for instance, for the ethics board, I'm their attorney and I go to every meeting with, but we're paying them outside counsel
Well,
fees.
And they probably can't advise us on a case that they were the neutral on
Right.
previously, in one of these
Yeah.
discipline processes that
Yeah.
you all have.
Yeah.
But think of that.
Yeah, and I think those aren't filed as ULBs very often,
Right.
because they go to regular arbitration.
Yeah, there's a bunch of processes.
So they have to do something else wrong to,
Right.
has to be another wrinkle to get it to here.
Sure. Okay. All right.
And then with the board's indulgence, I also have some miscellaneous information to provide you that's not on the agenda. If I can, as you know, AWU, the union that is AWU workers, went to the pipe fitters and plumbers, went to arbitration. Arbitration held in favor of the union on the major point, held in favor of the city on some minor points. The major point being an upfront 5% wage increase, and then 1.5%, 1.5%, and 1.5%. And I'm doing my best trying to summarize this, again, not being a labor person. Then that went to the assembly, and the assembly had to have a supermajority to accept it, and they did not. And you can, of course, listen to the assembly notes yourself. The assembly reasoning was, no, we retain jurisdiction. Of course, they do under the code, but also we have other things to consider in addition to just private sector comparisons. Because the arbitrator basically found in private sector our employees deserved more in comparison. So anyway, they now face whether to do a strike vote. If they do a strike vote, and this year they vote in favor of strike, and our understanding is, it's being debated at this point. If anybody makes an allegation of an illegal strike, it would come to this board. And they are, boy, we need an attorney. What are your attorney? I don't think anybody's taking the position right now it would be an illegal strike, that they have strike rights under our code. But that shows you why you need an attorney. And you need to be quickly get this person on board.
Wow. Yeah, we do. Because
So-
I don't just
Yeah.
does our code have strike classes? I mean, and
We do.
are they twos or threes or
I
one?
believe they're twos, so they have a limited right to
So
strike.
they had to go through the interest arbitration process to
Right.
get there.
Right, and it's not binding arbitration, so, and there was an earlier legal case about this 4 or 5 years ago, and so, but apparently we don't need to worry about that till the end of next week. So I wanted to, if I had had more time, I probably would have called some
Do
of
we
these
know if the parties
attorneys.
are attempting to bargain at all?
I don't know that. I would assume they're in touch with the counsel for both sides are in touch with
One
each
would
other.
hope.
but-
One would hope.
Yeah, so, but anyway, so then that just underscores the importance of getting this board moving again.
Yeah. Okay. Well, what other juicy things do you have in your
Giving you an
pocket?
Unfair labor practice, strikes.
Nice.
That only lacked one vote passing, didn't it?
I don't remember, I thought it was about half and half, and it may have been that close. Oh, that's right, because we have a new group now.
It was, and when I read it in the paper, I thought it required
8, I think.
8, and they had 7.
Huh.
Now, and that does bring up an interesting question, because we have a whole new assembly, not a whole new, but quite a few, 4 new
Yes.
people.
It has a different balance.
Right. Although for any political body in this stage and age, a 5 would be pretty hard to choke down.
Mhm.
Right.
So,
I'm sure that's what got the other people's attention. They said 5.
and I'm, of course,
One and a
speculating,
half.
but maybe that's why the pipe fitters were waiting to see who got on the assembly.
Yeah. Huh. Interesting.
So. And by the way, do you keep these notebooks, or they go back and forth? I bothered to print out your code as to unfair labor practices, just in case you wanted to look at them.
Thank you.
Thank you.
Didn't bother to strike like this.
Yeah, you can save that for next.
Yeah.
I'll just leave my notebook here. I took
Okay,
the
thank you.
the lightweight version.
Okay.
That's it.
Can I keep this?
The notebook, or
The notebook.
do you want to take the contents with you and then leave the notebook, and I'll make you another notebook?
Why don't you just make it, then we'll keep all of it.
Okay.
That way I won't lose it.
Okay.
All done?
Still have 7, 8, 9 on the agenda.
7, 8, 9. So, member comment?
Nothing in particular, no. Thank you for
Yeah.
For the information.
I greatly apologize to the board for not being there tonight. I had full intention. I truly thought it was one next week.
Join the group.
Can I actually now be audience participation? If I could mention one thing to everybody is, one of the things we need to address here is telephonic, because you are one of the boards that's called regulatory and adjudicatory, and those boards can't participate telephonically. We are in the middle of putting in a code rewrite that says when one of those boards is not acting in an adjudicatory capacity, they should be able to appear telephonically.
Sure.
Okay.
In fact, I drafted this nice little ordinance because we had the same problem, like for instance, the AERC, the Anchorage Equal Rights Commission, they don't do any adjudicatory. They do all outreach and diversity, and yet they're having attendance problems because the poor people from, Nikiski can't attend. So we were trying to change that, but then it came up with, now we're all trying to define what the word adjudicatory means. That's sort of interesting in your board because really you are dealing with rights and people's interests. Like even today, would this have been a non-adjudicatory? Well, I'm not sure. You made decisions about the call your order. So it may not help your board as much. So we're trying to think that one through, but there's certain boards that clearly shouldn't have to appear just because they're under that part of the code section.
Well, clearly when we're over here accepting evidence and testimony
Yeah.
and all that kind of stuff, we're in an adjudicatory role, but I would define it narrowly over there as that's when you're doing that. The rest of it's all just procedural decision making.
And we've done it sort of board by board in the past. For instance, the port commissioners, they're from all over the place. Our investment boards, we want expertise from Washington, D.C. And so we put it right in the board, the Title IV board stuff, that they can appear telephonically. But that is something here because you've had telephonic a couple of times. And so we really
Okay,
do.
mine was in January.
Yeah, so we need to address that at some point. And that will probably be me, because that's a straight MOA procedural issue.
So that might be on our next agenda to take action on that.
And I guess it's something that for all of you to be aware, we may have to call a meeting. You have to have a week notice, don't you, Amy, you think? I think it's a week notice.
It was
I don't know.
24 hours for a special notice, 48 hours for just like a regular, but we like to give the public at least a week.
Okay, but if anything goes sideways next week, you might have to do some pretty short meeting notices. And those, due to the nature, if it does involve a strike, that probably those should not be done telephonically.
Sure.
But again, I'm not even sure you'll get called on it, even if it goes to that direction, because it's probably not an illegal strike at this point. But a slowdown would be, so we'll see. That's all I have to interfere with.
Yeah. Yeah.
Thank you very much.
Thank you. Okay, Ty.
Yes. We down to 9?
I think so.
All right. So I'll make the motion to adjourn.
Second.